Support comes from the Missouri Forest Products Association, honoring Arbor Day on April 26th, with an ongoing commitment to sustainable stewardship and conservation of Missouri's forests. ChooseWood.com.
Welcome to St. Louis on the Air. I'm Sarah Fensky. This was a busy month for the legal profession in St. Louis. I guess it's always a busy month for the legal profession, but it was in particular this month a lot going on. We saw lawsuits and threats of lawsuits related to the coronavirus. We saw the death of Michael Brown again making headlines and again spurring some complicated legal questions. And we saw a local politician accused of breaking the law. Or did he? Well, our legal roundtable is here to sort it all out. And today, that is Nicole Gorofsky. She's a former prosecutor, now in private practice at Gorofsky Law. So, Nicole, thank you for joining us.
Hi. Thanks for having me.
And this month, we are pleased to have Eric Banks back with us. He is a former state prosecutor and city councilor for the city of St. Louis, and he is now in private practice at Banks Law. Eric, welcome back.
Thank you, Sarah.
And last but not least is our founding panelist, Mark Smith. He's an attorney and also an associate vice chancellor and dean for career services at Washington University. Mark, welcome.
Thanks for having me.
So I want to start by talking about Michael Brown. And yes, we do still need to talk about Michael Brown. Last month, just before the 6th anniversary of his death, St. Louis County prosecuting attorney Wesley Bell announced he had reopened the investigation into Brown's death, which of course was at the hands of a Ferguson police officer. So he announced that he reopened it, and he announced at the same time that he was closing it. Mark, what reason did he give for that?
Well, he said basically that he couldn't prove the case. And he said, I would not only have to prove his guilt beyond a reasonable doubt, but I would also have to disprove its self-defense argument beyond a reasonable doubt. And so, his decision is consistent with what the grand jury under McCulloch did, and then also the findings of the Department of Justice. I think Bell was clear that he's not saying that what happened was right. He's just saying, I cannot bring a case here. And under the Missouri ethical rules, there's a specific section for prosecutors. It's section 4-3.8 of the ethical rules that says that a prosecutor should refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. Now, probable cause is a lesser standard than what County Prosecutor Bell, alluded to.
So the standard is not that you have to be able to prove it beyond a reasonable doubt. You just have to prove you have probable cause.
Yeah, but I remember on a show, one of these shows we did 10 years ago or something, and when Jennifer Joyce was the prosecutor, I said, well, they can prosecute whoever they want. And then I'm in my office the next day and the phone rings and it's Jennifer Joyce and she's telling me, hey, I got some ethical rules. I can't just prosecute anyone I want. I have to do what the evidence supports. And I think, the Department of Justice findings were that given the state of the law, I think people can have a real problem with what the state of the law is in terms of the protection it affords police officers. And I also think we all can probably have a real issue with the fact that these jurisdictions were forcing police to interact with the poorest members of our community as a fundraising technique for their little municipality. Well, that doesn't mean under the state of the law as it is when it happened that Bell can bring a charge. So I don't disagree with what he did, but I understand it's a very difficult decision.
Nicole, do you think that Wesley Bell used the right standard here in deciding not to bring charges?
So just to clarify the standard, it's a probable cause standard to get a felony case from what you call associate circuit court to be bound over into circuit court. So basically, to charge any felony you have to have probable cause, which means it's more probable than not, like a 51% kind of standard, although we're not technically supposed to say 51%, but it's more probable than not that the person committed the crime. That's the standard for charging the felony. But then when you go to trial, you have to prove it to a jury beyond a reasonable doubt. So a prosecutor who is thinking, because prosecutors are always thinking about trial, a prosecutor who is thinking about, I have to take this case to trial, is going to be thinking, all right, how am I going to prove this case beyond a reasonable doubt? Because just because you have probable cause and you get to the charging stage doesn't mean you can get all the way through trial.
So Wesley Bell did face some pushback for this. Gerald Christmas is an attorney in town, and he said this: the fact that Bell is saying he can't file charges is outrageous. Proof beyond a reasonable doubt is the jury's decision. Eric Banks, I'm wondering, do you think Gerald Christmas is right about that?
Well, it can be the jury's decision, or as we saw in the Stockley case, it can be the judge's decision as well. I certainly respect Gerald Christmas. He was a long-standing prosecutor in the circuit attorney's office, does a lot of high-stakes litigation, and is a superior activist. I just disagree with him on this one. I will not be out there leading the charge, asking for Wesley Bell's resignation. I think he did the best that he could do under these very difficult facts. And as an aside, perhaps we would not be having this debate if the Ferguson Police Department had body cameras back then.
I think that's a good point. Looking at Wesley Bell's decision then, I mean, it seems like this case has certainly torn up this town. It's torn up this town in some ways that have led to really good changes. But it's easy to see that if he brought this case and couldn't win a conviction, it could lead to all sorts of problems. Do you think that's a fair consideration for a prosecutor to be thinking about? Nicole, is that something they're allowed to have on their minds?
Certainly. I mean, when I was a prosecutor, I was a child sex abuse prosecutor. So you always have to think about the potential of putting a victim through an entire trial, which is traumatic in and of itself, and not winning, because that has an effect on families. It has an effect on communities. And yes, I do think that's a relevant consideration. Now, on the flip side, I also believe that a prosecutor does need to take some risks in some cases because it's the right thing to do, and that is a fine line to walk. So I'm not going to, Sunday morning or Monday morning quarterback. I guess I'm not a football person. Monday morning quarterback in this situation, because I just think we don't know all the facts. We don't know everything that was presented to Wesley Bell in this case. So I just think that was Bell's decision to make, and a lot of other institutions made the same decision.
We have a couple of callers interested in joining us, and our phone lines are open. If you have thoughts on this, or particularly a legal question for our panelists, you can join us at 314-382-8255. That's 382-TALK. You can also tweet us at STL on air, or you can email us at talk@stlpublicradio.org. Let's go to Tom, who's calling from Afton. Tom, hi, you're on St. Louis on the Air.
Thank you. I'd like to ask your legal panel about something that's in the Darren Wilson's grand jury testimony. I don't think it's gotten enough attention, and I don't know how to reconcile it with the use of force law, which of course has changed since that time. But in his testimony, I don't have it in front of me, but Darren Wilson basically says, aren't you going to ask why I shot him when he was no longer dangerous? And it's because of what he might do in the future to another cop. And to me, that sounds like he admitted to the grand jury that he was not shooting Brown to remove a threat, or to protect himself, but because of what he guessed Brown would do later. How can a layperson reconcile that with what the law was at the time?
Tom, that's a great question. I don't know if anyone on the panel has it. Mark, do you have a feeling about that?
You can look at the, I think the DOJ, and this was Obama's DOJ, issued their report in 2015, and it's like almost 100 pages long. And they say they say a couple of things in there that are interesting. And this particular statement the caller's talking about, I'm not familiar with. But they say, this narrative that, and I'm quoting from him, that Wilson shot Brown when he was in an unambiguous signal of surrender is inconsistent with the physical evidence, or otherwise not credible because of internal inconsistencies. He says, the report says that the defense fits within the law. So I think that DOJ report, I would encourage, if you listeners want to learn more, that's probably the best source of information, I think, about what happened here. And we'll never know. I mean, we're never going to have absolute metaphysical knowledge of it, but it seems like a pretty balanced report to me.
Yeah, as you note, that is coming out of Obama's Justice Department. That was Eric Holder
correct.
running it. This was not the Trump Justice Department. Let's go back to the phone lines. Ron is calling from Ferguson. Ron, hi, you're on St. Louis on the air.
Yes, in the fact that the federal, the state, and local prosecutors looked at it, I think it's time to put it aside and move forward. We have 1,600 homicides in the St. Louis region since Mike Brown, and I think prosecutors should be focused on solving those murders.
Ron, thank you so much for that. I appreciate hearing that perspective. I do know there's a lot of people who share those thoughts. Actually, we're going to go back to the phone lines for one more call. I understand that Attorney Gerald Christmas, who I quoted earlier from his comments in the Post-Dispatch, that he is here on the phone lines with us, and that's always welcome. So, Gerald, hi, you're on St. Louis on the air.
Hi, how are you doing? I just heard you mention my name because I was listening.
Well, thank you, Gerald. I appreciate you tuning in, and I did not take your name in vain, but I am curious to hear your thoughts on what the panel had to say about the quote I read to them.
At first, I want to say that I think you have an excellent panel on there, and they are correct. And attorneys will differ in our opinions, but the standard for Wesley bail is probable cause. And I maintain that this case deserves to go to trial. Certain cases have to be tried when you're a prosecutor, and this is one that has to be tried, and there was probable cause to charge him. The burden is on the jury as to whether or not he proved this case beyond a reasonable doubt. And what I don't like, and what the family, especially Michael Brown's mother, doesn't like, is that two prosecutors have arbitrarily made the decision that this case does not deserve due process of the law. And we also had the ruling, I'm sure you're going to talk about a little bit later, where a grand juror went so far as to sue, to speak about how bogus the procedure was in the grand jury when the case was brought by Bob McCullough. And that alone, Wesley Bell started off talking to Leslie McSpadden, apologizing for the way that family and that case was treated in the grand jury. And that alone deserved a second look by either a preliminary hearing in open court to determine probable cause, or by another grand jury without the issues that grand juror was raising in the way that case was presented.
Gerald, thank you for that. I think you make a lot of good points there. I do have one quick follow-up question for you. I know that Michael Brown's mother, Leslie McSpadden, was quoted in that same story, and she said she didn't feel defeated by the decision, but she did say that she wished Kim Gardner was in charge of this case instead, that the St. Louis City Circuit Attorney, she thinks Kim would have come to a different decision here. I'm just curious, in your opinion, do you think Kim Gardner would have gone forward with this, even with that same set of facts?
I can't speak for Kim. I think she just had more confidence in Kim because of the decisions that she's made in other cases in the city, but I don't know. I can't speak for Kim.
Yeah. Well, it's such an interesting case. And Gerald, I really appreciate you calling in and sharing your insight to this. Gerald mentioned this grand jury case, and that is actually what I want to talk about next. However, we need to take a quick break here. We're talking to our legal panel today that consists of Mark Smith and Eric Banks and Nicole Gorofsky, all fine attorneys. We're going to take a quick break here, and when we come back, we'll talk about proceedings related to the secrecy of the grand jury. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU.
Support comes from the Missouri Forest Products Association, honoring Arbor Day on April 26th, with an ongoing commitment to sustainable stewardship and conservation of Missouri's forests. ChooseWood.com.
Welcome back. Today is our legal roundtable, and today that includes Mark Smith. He's an associate vice chancellor and dean for career services at Washington University. We're also joined today by Eric Banks. He's a former state prosecutor and city councilor for the city of St. Louis. He's now in private practice at Banks Law. And last but not least is Nicole Gorofsky, and she's also a former prosecutor. She's now in private practice at Gorofsky Law. Now, just before the break, we were talking about the reopening and then closure of the investigation into Michael Brown's death. And Attorney Gerald Christmas called in, and he did reference a case that I am very excited to talk to you guys about because I'm personally fascinated by this. And that is, it's another legal matter related to Brown's death. A St. Louis County woman who served on the grand jury that Wesley Bell, the former St. Louis County prosecutor, set up to investigate the death of Michael Brown. She wants to speak out about what happened during the proceedings. She took this to state court. She lost there. She went to federal court. A federal judge said no. She took it to the Eighth Circuit Court, and in this past month, they ruled that she cannot speak out. Nicole, what is the reasoning for this, that this woman can't talk about her experiences on a grand jury of a matter of great public interest?
Yeah, so the Eighth Circuit basically reviewed it under, First Amendment freedom of speech, issues, and determined that basically it is a restriction on content-based free speech, and because of that, it has to get the highest level of judicial scrutiny, which means it's a really high standard to say that she can't speak. But then on the other side, the court said the government interest actually meets that high standard because of the safety of grand jury members and their right to be free from harassment for any decisions that they make, and their right to avoid public criticism for the same thing, the decisions that they make.
But Eric Banks, I want to ask you about this because it seems like it's less that grand jurors are being shielded from criticism here and more that the county prosecuting attorney is being shielded from criticism here. She has argued in her legal briefs that prosecuting attorney Bob McCullough mischaracterized the views of the grand jurors, that he did not tell the truth about what happened there behind closed doors. Should this standard, I believe Nicole is probably accurately describing what the standard is, but should this be the standard in a case like this where it's a public official who could be in the hot seat here?
No, it should not be the standard. And this is one of those very, very rare occasions when I don't have schizophrenia between what I think as a human being and what I think as a lawyer. Certainly as a human being, I believe that this should be changed at a minimum so that it can be decided on a case-by-case basis. But even as a lawyer, just because this standard in terms of secrecy of the grand jury has been with us hundreds upon hundreds upon hundreds of years, that doesn't make it right.
Nicole Gorofsky?
Well, when I read this, I thought, well, maybe it is the right standard, but maybe a juror, because it's all about protecting that grand juror, maybe the grand jurors should also have the right to waive that for themselves. I mean, maybe they shouldn't have the right to reveal the names of the other grand jurors or, reveal their identities. But I didn't completely understand why a grand juror wouldn't have the right to waive those protections for him or herself.
So we've got two panelists who do have some concerns about how this is being applied in this case. Mark, what's your thoughts?
Yeah, no, I have a little concern too. We have this law that says you can't do it. You can't disclose grand jury, and if you do, it's a criminal offense. So she's saying you violated my First Amendment right. Anytime we consider a law that impacts fundamental rights, and free speech is one, the court uses this strict scrutiny analysis, and they say the law has to further a compelling government interest, and it has to be narrowly tailored. And kind of like when I was in law school in the 80s, then the professor would kind of give you a knowing wink and said, and nobody ever satisfies that, So it was like, if they say strict scrutiny, it's going to go down. And in this case, they didn't. And also, I think, I agree with Eric. When you look at some of the reasons for it, some of the reasons for this secrecy are to keep an accused who is then not indicted from public ridicule. Well, everyone knew who was the accused. you're not worried about the accused fleeing because it's after the fact. A lot of the underlying reasons don't apply in this case. And so I think it would be interesting if this, if they tried to appeal it to the Supreme Court, if the Supreme Court were to take it. They've been doing some pretty interesting things with free speech. I could see the Eighth Circuit getting overturned on it, but who knows, and just for your listeners, the Supreme Court, just because you appeal to the Supreme Court doesn't mean they take it. They could just say, we'll pass and we'll wait for another case.
I did think it was interesting. You had 3 Republican appointees who made the decision in this case. You just need a 3-judge panel. Do you think there might have been a different decision at the circuit court level or the appellate court level if there was a more liberal panel, or is this pretty well settled when it comes to cases like this?
The Republicans have been doing some pretty aggressive things with speech. There was this case at the Supreme Court a couple of years ago about union dues and saying that, there had been this longstanding precedent saying, well, I don't have to pay dues for my union to give to political parties, but to represent me, I do. And under speech grounds, the Supreme Court, led by the conservatives, said, yeah, not if you're in a municipal, like a union that represents police officers or teachers union, because by saying that you should get more money, it's political speech, because you're saying then if I'm a teacher that the police officer should get less. And everyone kind of saw it coming, but it was still out there. So I don't think this is a Republican, Democrat, conservative, liberal thing.
There's one more question I had about this, and that when Wesley Bell announced that he, again, was closing the investigation into Michael Brown's death, he outlined a series of reforms. And Eric Banks, one of them caught my eye. He said that going forward, quote, all homicide grand jury proceedings will be recorded once they resume after current pandemic delays. And he'd kind of pitched this as a reform. Does that speak to this issue? Or with this secrecy, is that not even going to make any difference?
I'm not sure how he can do that. I hope he can, but I'm not sure how he can do that under the statutes that keep grand jury proceedings secret.
Yeah, I was wondering the same thing. Nicole, any thoughts on that?
I mean, I think he can have them transcribed and, have a court reporter in there, but I don't know how it could ever be released. So right now, under the Missouri statutes, there is a mechanism, there is a statute that says if any witness is given immunity, then those grand jury sessions have to be transcribed, recorded. So we do have one situation, and I could be wrong, but I think it's my understanding that in most other states, grand jury proceedings are recorded. I think Missouri is somewhat of an outlier in that. But at the same time, I don't know how our law would ever allow for those transcriptions to ever be released anywhere.
It's interesting. Well, Mark, I hope that you are onto something here and that the Supreme Court takes this case, because I find the issue so fascinating, and I would be very interested to see what they might do with this.
It would also give us something to talk about next year.
There you go. We could look forward to that.
Right.
We could say there's an important case coming out of St. Louis. Eric?
And I don't have to look up new research. Right. Yeah.
And to Dean Smith's point, the last time I took a case or tried to take a case to the United States Supreme Court, it was through the process of writ of certiorari, which basically means the Supreme Court does not have to accept this case, but they can if they want to. That year, only 1 out of every 711 cases that were filed with the United States Supreme Court via writ of certiorari was accepted.
And Eric, please tell me yours was one that was.
No, it was not.
Oh, I'm sorry to hear that. Well,
close, but no cigar.
I'm sure you were the second in line of the 1 in 711.
That's right. They should have graded on a curve.
That's right. Well, one more case I want to talk about here that involves some pretty intense politics, and that is Democrats want a Republican state representative booted from the ballot. This is Nick Schroer, kind of a controversial guy out from the St. Charles County area. Now, he owned a home in the district he represents in Jefferson City, but he wanted to get his kid into a different school district. So he and his family bought a 4-bedroom house in that school district, and then this Representative Schroer supposedly moved in with a pair of women who were not his relatives, 2 older women, and this house is still in his district. Now, the Democrats had a private detective looking into this, and they say that his truck was never at this home with these two unrelated women, that it was always parked in this house where his actual family lives, and they're suing him, alleging this is a fraudulent scheme. Nicole, do they possibly have a case here that could result in his removal?
So when I first read this, I thought, no way. There's no way they have a case. Then I looked further into this, and there are actually statutes that allow for this case and potentially even the remedy that they seek. So basically, it's in the Missouri Constitution that state representatives have to be residents of the county that they represent. And then there's case law as recently as 2016, which says that residency requirement is not as simple as just, leasing a property. It's really the whole purpose of it is for that candidate to be sufficiently familiar with the people and the issues of the district they seek to represent. So I don't think they want that to just be, putting your name on a lease and not being there. So this really could be an issue.
Eric Banks, thoughts on this?
And this is a reoccurring problem. I would invite the listeners' attention to the September 14th, 1997 article by Terry Gainey and Tim O'Neill of the St. Louis Post-Dispatch entitled "The Stealth Senator, J.B. Jet Banks, No Relation." And it mentioned how the Attorney General of the state of Missouri tried to come after Senator Banks by saying that he didn't live in the 5th senatorial district that he represented. It's just a reoccurring problem. It's very, very fact specific. This is a good example of why when I was city councilor, I would not hire an attorney unless he or she was already living in the city. The Civil Service Commission rules give new employees a year to move into the city. I said, I'm not going to voluntarily buy an investigation. If the person already lives in the city, I'm going to assume that he or she is not going to be moving out of the city just because they got a city job. But if somebody does not live in the city when I hire them, then 365 days later, I have to be detective and try to find out where they really live.
Yeah, that seems like we hear so many stories alleging, these cops, the city has these residency rules, the cops aren't actually living here. You always hear allegations. It just seems so hard to prove. Mark, one thing that caught my eye on this is he voted from this house where the detective says he hardly ever is. Is this potentially a bigger problem for him if he voted from a place that he's not actually living?
Yeah, I as long as he didn't vote at the other place, I think he's probably good. But I think, he's got an arguable argument that is his residence or domicile, which are kind of two different concepts. I don't think he would go to jail or anything for that, but I do think he's on much weaker ground in terms of being able to stay in his seat. This residency also comes up, we were talking about it in these election, comes up in the tax area as well, because a lot of times people will try and say, well, I live here in New York City, but my residence is in Texas, and so I should have to pay Texas taxes, which are much lower. And they'll look at all these, and it, as Eric said, it's a very fact-specific, like, where's your driver's license? Where are you registered to vote? Where do your bills come to? Where do your bank accounts? In one case, I remember reading about when I was doing this kind of work, one of the deciding factors was where the guy's dog was, because his dog was in Texas, and they said, well, if your dog's in Dallas, yeah, you're probably a resident of Texas. I just found that that's how detailed it can get.
That's interesting. You'd think by the same standard, children would be some pretty compelling evidence, since the children are.
Sometimes I'd rather have the dog in my house than the children. So,
Mark, I hope your children aren't listening. I know they're big fans of the Legal Roundtable. That's what teens love to listen to. But we're talking today to our Legal Roundtable, and that was Mark Smith. We're also talking to Eric Banks and Nicole Gorofsky. We do need to take a quick break, but coming back from that break, we're going to talk about a high-profile lawsuit. This involves the city of St. Louis and a couple of bars that they shut down over their coronavirus policies. This is St. Louis on the Air on St. Louis Public Radio. That's 90.7 KWMU.
Support comes from the Missouri Forest Products Association, honoring Arbor Day on April 26th with an ongoing commitment to sustainable stewardship and conservation of Missouri's forests. ChooseWood.com.
Welcome back. We are talking to our legal roundtable, and today that includes Eric Banks. He's a former state prosecutor, former city councilor for the city of St. Louis. He's in private practice in downtown West at Banks Law. And we're also joined by Mark Smith, an associate vice chancellor and dean for career services at Washington University, and Nicole Gorofsky, a former prosecutor, now in private practice at Gorofsky Law. I want to talk about a high-profile lawsuit involving the coronavirus. This has sort of been the fabric of our lives in the last 6 months. The city shut down 2 downtown bars in late July. Start Bar and Wheelhouse were both popular with the younger party crowd. And one of these businesses actually posted a video on its own business account of the scene inside one night. And yeah, it looked like a party. There were not a lot of masks being worn by those patrons. So the city shut them down, but they fired back. They hired Scott Rosenblum, very prominent attorney here in town. In their lawsuit, they say bar staff wore face masks. They also required customers to wear masks when entering or leaving. And although bar management did limit patrons to no more than 75% of each bar's full capacity, which was then the standard, they left plenty of room for social distancing, but the customers just chose not to distance. There's a real question here, and I am going to put this one to Nicole. Nicole, are they responsible for their patrons' conduct?
Yeah, I thought this one was interesting because it was sort of a novel argument that, look, we put the rules in place. The patrons just chose not to follow those rules. But according to, the court, it was rejected. Yeah, again, like all of these other arguments about coronavirus. So, apparently our court system seems to agree pretty consistently that public health trumps all, and dangerous activity is dangerous activity, whether the bar is having a problem policing it or not. So, and I'm not completely understanding the rule, the part where they say that they were having people wear masks as they entered and left, because it was my understanding that they had to wear masks inside. So I'm not sure if they were completely following the rules. But they said that they did leave space for social distancing. The patrons just chose not to. And so I did think that was a novel argument. It just didn't fly with court.
It's interesting. I think they were going for what restaurants require, is that you have to wear your mask when you're walking to your table. And then when you sit down and you're eating and drinking, of course you can't wear it when you're drinking. But at a bar, we've all been there. You can stand around sometimes for hours very close to other attractive people, and you're not going to wear a mask for that. It does seem like that ended up being a bit of a problem based on these videos. Eric Banks, I'm curious about your thoughts about this. Mayor Lyda Krewson made some public statements that businesses would not be asked to be the mask police. And they're pointing out, hey, here the city's now punishing them for not being the mask police. Are those comments a problem?
Well, let me get to the real issue before I answer your question. Where can I find this bar where I can stand around for hours and see attractive people? Because as soon as the virus is over with, I will be there with bells on. But more or less to your point, the reason why I thought that this lawsuit, and I'm looking at it now on the other computer, was a true work of scholarship and was very well written. It's just on the wrong side of the political equation in terms of 2020. This virus is the worst thing we've seen since the 1918 Spanish flu. And if somebody's going to have to be inconvenienced by not being able to get their drink on while we try to keep hundreds of thousands of additional Americans from dying, because we're just going to have to take that hit. I think the analogy is similar to when you own a night spot and somebody gets shot inside. I've been on both sides of that issue. I've represented people who were injured. I've represented businesses. And basically, the bottom line is, while a business owner needs to take reasonable measures to prevent a tragedy from occurring, a business owner cannot guarantee that. And it's just a cost of doing business. So yes, the government can make you the mask police. And that is one of your costs for doing business.
Mark,
in this case, Sarah, I was going to say, in this case, the complaint from the bar owner was that the guidance from the city was vague and that they were not given any kind of notice before this came in. So they're more procedural arguments. And the judge said no to their temporary restraining order attempt. And then I thought it was very telling. She said, and I expect them to work this out. They're already talking. So I think, they're going to come up with some kind of an agreement, and this case will probably go away. But could come up again in some other spot. There are lots of bars in the city where this could happen.
Yeah, I think if they hadn't posted this video, they probably could have flown under the radar. They said the health inspector had just given them a thumbs up. I've certainly heard anecdotal reports that there are many other bars doing the same thing. And Eric, I can let you know where those bars are, but I know you want to wait until the pandemic is over, so...
That's right. I'm a responsible citizen. I wear my mask.
That's why we have you on the roundtable here. So I described that as a very high-profile case. Well, talk about another high-profile case, and this is about as high-profile as it gets. The McCluskeys, back in the news. We've talked about them in the last two legal roundtables. They spoke at the Republican National Convention last night. An interesting speech. But this case is just absolutely drenched in pretrial publicity right now. Generally, it seems like lawyers are always telling people, don't talk to the media, don't talk to the media. Can it hurt this couple at this point to discuss their case in front of the entire nation at the Republican National Convention? Mark, if you were their lawyer, would you tell them to shut up?
Well, I mean, this is kind of like we were talking about before the show. This is not about the law. This is all about politics, I think. They've already got a get out of jail free card in Governor Parsons, who said, if they get convicted, I'm gonna pardon them. So
they have nothing to fear if they're convicted. That's just
and
nothing.
I also think the case is probably, given the strong stand your ground law in Missouri, the Castle Doctrine. I think it's going to be tough to convict them of anything, and I think it looks like they've made a lot of money, and now their chance to just be on national TV and be kind of superstars and maybe go on the circuit speaking and do something other than practicing law, which can get to be a grind after a while.
Eric, do you think it would be tough to convict them even with a St. Louis jury? I feel like my fellow city residents, what I hear is a lot of animosity for this crew, and maybe they're counting on the pardon, and Mark's got a great point there. They certainly have raised their national profile, but I could see them getting convicted here.
Well, certainly that is a possibility. I will also say that while I respect and appreciate Kim Gardner, I'm glad she won a second term, but she has had, in my opinion, some missteps along the way, such as prosecuting a governor without a photograph. That certainly ended well for her, but it didn't start off that way. That being said, I think that she demonstrated Solomon-like genius propensity by announcing the prosecution for UUW, but in the same breath mentioning how these would be candidates for the diversion program, and she would be willing to consider it. I said, my goodness, that is incredible. On one hand, you're demonstrating to the world how reasonable you are. You're not asking for 5 years in the penitentiary for these folks, which you would never get anyway. But two, you are using a national platform to demonstrate one of the hallmarks of your administration, your fine diversion program.
So, Eric is very impressed with Kim Gardner here. I'm glad he brought Kim up because they have sought to have her disqualified from the prosecution. They note that she mentioned this case in emails sent by her campaign. Again, this seems like something where I know I'm old school, but back when I was a young reporter, not only did lawyers tell their clients not to talk to the media, but prosecutors would always say, well, I can't discuss these cases because I'm here to be impartial as I pursue justice. Nicole, was that a problem that Kim Gardner talked about this in campaign emails?
Yeah, I mean, I think this comes more down to campaign ethics rules than it does the lawyer ethics rules because, the lawyer ethics rules basically say you can't talk to and prosecutors have, I should say, more strict ethics rules about talking to the press than other lawyers. So for regular lawyers, and that includes criminal defense attorneys, so they can get away with more than prosecutors can. The rule is basically you just can't say anything that is likely to influence the case. For prosecutors, they have to be much more careful. They're much more restricted on what they can say to the press. Now, this is more, I think, the McCluskey's argument in trying to disqualify Gardner is more directly related to they are saying that she used their case in trying to get reelected, and that a campaign committee that is tied to her used their case in some advertising, some, email advertising. I am not sure. Certainly, I'm not a specialist in campaign rules, but I am not sure that that's going to really make a difference in the actual prosecution of them. They may, have to flip that and say that that's some kind of campaign issue, but I don't see how it's going to be any kind of conflict of interest for the prosecutor in the actual prosecution.
Okay, so you don't see her getting removed for these email mentions or anything like that. She can keep pushing this case.
I don't see it.
So Kim Gardner, always in the news. She's definitely a figure that inflames a lot of passions. And in the last month, the Missouri legislature made some moves to try to strip power from her. One of them was a proposal to give concurrent jurisdiction to Attorney General Eric Schmidt. And I guess we should start by saying, what does that even mean? Eric, do you feel this is one you can take for our team here?
Yes, I used to say when I was with the city that the average person could be prosecuted for the same offense by 3 different entities, that being the city councilor's office for municipal violations, the circuit attorney's office for state court violations, or the U.S. attorney for federal violations. And if you look hard enough, almost every human action could violate one of those 3, if not 3 concurrently, spheres of influence. But to get to this instance, I don't like to use the R word too often, racism, but I think that this is unchecked racism. I think that they're doing this because she is a Black woman who is not cowed, who is not intimidated. They would not do this to a white prosecutor, male in outstate Missouri, no matter what he did. So I think that this is just a attempt at intimidation, and I hope the citizenry does not allow this to happen.
Nicole, do you share some of those concerns?
Yeah, I do. And it also flows into, there was a state representative, Onder, who made a proposal that to allow Parson to have the authority to remove Gardner or any, I guess, prosecutor anytime he wanted, I guess. And that just, to me, leads to removing prosecutors for political reasons they disagree with. But it was aimed at Gardner specifically. And that is terrifying. I mean, it is just so unbelievably wrong. In my, history of having been a prosecutor through now, which is, over 20 years, the only time I've ever heard of a prosecutor being removed from their seat is, I believe he was caught with child pornography. So literally having committed a criminal offense. So, I mean, this is, if we're talking about the free speech that we were talking about before, this is the definition of, content-based, choosing who you like and who you don't like based on your politics, and possibly based on, yes, race, gender, and all of those other illegal reasons. And this just cannot be. Thankfully, the Missouri prosecutors also came out and were opposed to everything related to this, too.
I was going to say, Nicole, I'm glad you brought that up because there is a Missouri Prosecuting Attorneys Association, and this has all the elected prosecutors across the state. A lot of Republicans in this group, they came out unanimously against this thing. Mark, were you surprised by that?
Yeah, no, I was not surprised. I was glad. It was nice to see them because I agree completely with what Eric and Nicole said. I mean, she's a strong Black woman. She won her election. You got a lot of Republicans in Jeff City who are not happy about that, and they want to go after her. And I'm really glad the prosecutors in the other area said, hey, this is going too far. We've got these norms, and you're going beyond the norms.
We have another case I want to just get to real quickly. We've just got about 3-4 minutes left. But businessman John Rollo, he was indicted in the charges brought against Steve Stenger for all the corruption in St. Louis County. He wants to get out of prison early. He'd done a few weeks of a 17-month sentence when he started asking for a compassionate release, citing the coronavirus. That was in July. Well, then his cellmate died after contracting COVID-19. And now Rollo's attorney has told newspaper reporters that Rollo tested positive for the virus. This was on August 2nd, that he's been very ill. He is having difficulty breathing. He says he has a compromised immune system. Prosecutors had previously fought pretty hard to keep this guy locked up. Was that a mistake? Should they have allowed John Rollo out? This is a white-collar criminal, as we like to say. Nicole, thoughts on that?
Yeah, I mean, this is an issue that is happening across the state and across the country. I mean, inmates are getting coronavirus just en masse. And this guy has now actually gotten it. And I think, if he passes away, that's going to be a huge issue. And I shouldn't say it's terrifying for him in particular. It's terrifying for everybody who's in there. And, just because you get sent to prison doesn't mean you received a death sentence, and it doesn't mean you deserve to receive a death sentence. So, yeah, I think it's an issue.
And yet here's this guy, to play devil's advocate here. He took this taxpayer money through this bribery scheme, and he can afford a much better lawyer, in part because of these kind of schemes, I'm sure, than a whole lot of people who are still stuck in prison. Eric, is this a problem if we're letting guys like John Rollo out and keeping a whole bunch of other people locked up?
No, it's not, because this is a very, very high standard. The overwhelming majority of people who apply for compassion relief will not get it. And I've already thrown myself on the sword and told you about my ill-fated Supreme Court writ of certiorari attempt. Earlier this year, I represented a client trying to get him released for compassionate relief. And we had over 600 pages of medical records to support our claim. I'm not violating attorney-client privilege. It's just a matter, if you know where to look, you can see it on Pacer. So I'm here to tell you, most judges are not going to release people because of the virus.
Nicole?
I will say it's also my understanding that most federal public defenders, state and federal right now, that is the majority of their work right now during coronavirus, is trying to do these compassionate release motions, because I know that prosecutions have decreased significantly, and so they are spending a significant amount of time trying to get indigent people out as well.
And Nicole, do you have a sense that in some cases they are able to have success with that?
Now, that I don't know. I don't know if all of them are making it through the court systems yet. As you know, a lot of our court systems are stalled because they're closed, or they open and then they close again very quickly because of the coronavirus. So I haven't heard about many of them making it through the system yet.
Well, this is yet again another issue we're going to have to keep an eye on. It seems like there's some common threads running through Legal Roundtable, and certainly the coronavirus has been one lately. But I really hope this is the last time we have to talk about the McCloskeys. So I want to thank our panel for joining us today. That was Nicole Gorofsky of Gorofsky Law. And Nicole, thank you so much.
Thank you.
And Mark Smith, Associate Vice Chancellor and Dean of Career Services for Washington University. Thank you for joining us.
Thank you.
And Eric Banks of Banks Law. Thank you so much.
Thank you. Happy to have been a part.
Tomorrow on St. Louis on the Air, we'll talk to the Greater St. Louis Labor Council about why it opposes a plan to privatize the airport. And we'll also check in with St. Louis Bee Works. The nonprofit was storing hundreds of bicycles in the Lemp Brewery complex, and now that part of it's collapsed, what's next and what happened to that building anyway? We do want to invite you also to join our St. Louis on the Air Facebook group. You can just search for St. Louis on the Air on Facebook and request to join the group. We make it very easy to get in, and once you're in there, we're having all sorts of civil conversations about topics of interest, highlighting what we're going to talk about next, and getting your opinions on what we should do. So please join us on Facebook. Podcast episodes of St. Louis on the Air are available at stlpublicradio.org, or you can subscribe for free on Apple Podcasts, the Stitcher podcast app, or wherever you get your podcasts. St. Louis on the Air is a production of St. Louis Public Radio, 90.7 KWMU. Thank you for listening. I'm Sarah Fensky.
Support comes from the Missouri Forest Products Association, honoring Arbor Day on April 26th, with an ongoing commitment to sustainable stewardship and conservation of Missouri's forests. ChooseWood.com.